Later this month, the Supreme Court will hold 3 days of arguments over the president's health care law, but could the case fall apart before the justices ever decide whether the individual mandate is constitutional? Joining us now to debate that possibility, Elizabeth Wydra, Chief Counsel for the Constitutional Accountability Center, and Tom Dupree, former Principal Deputy Attorney General at the Justice Department. Thank you both for coming in today.
Thanks for having us.
Thanks, Shannon.
Okay, so what we're talking about is the very first day of arguments is committed to the Anti-Injunction Act, which basically the bottom line is this case ripe for review or not? Do you have to wait until someone is quote-unquote injured by the law before they can sue? Elizabeth, where do you think the court will go with that?
Well, I think it's important to remember that the taxing power is one of the most important powers that our Constitution gives to the federal government. When George Washington was fighting the Revolutionary War, he lamented over and over that the Congress at that time, under the Articles of Confederation, didn't have the power to tax directly. So I think it makes sense that there would be a law, the Anti-Injunction Act, that says that you can't challenge a tax before it's collected, because that could shut down the operations of the federal government that relies on that.
And by the tax, you're referring to the mandate, so people understand.
Exactly, yes. So there's this question of whether the minimum coverage provisions penalty, if you don't buy a minimum level of insurance, is a tax, and if so, does the Anti-Injunction Act mean that it can't be challenged until that tax is actually paid, which would be 2015 on your tax returns. So I think it's unclear what the court will do, but now that they've added more time to the argument for that section, I think we'll know a lot more after that day.
Yeah, they've added 30 minutes, Tom, of course, to that. So they're taking this position very seriously, the possibility. But again, as Elizabeth pointed, I mean, if that's where we go, then this case is not decided until after a lot of those teeth of the law kick in 2014. Do you think the justices would delay such a difficult decision?
Boy, if they delayed it, I got to tell you, you would hear a massive sigh of disappointment from both sides. Both sides of this case want the Supreme Court to resolve the merits. There are immensely important issues of constitutional law at stake. Obviously, the practical consequences are astronomical, whether or not this law is constitutional. And so, although this Anti-Injunction Act argument might be a sleeper issue, and it might give the court a route to the goal that enables them to avoid the merits, or at least defer the merits for a few years, I think that's going to be very, very disappointing. And I bet you a lot of the justices are going to be itching to get to the merits and resolve this case on the constitutional grounds.
Yeah, and they have taken the case, and they've taken all parts of it, the issue about mandates and severability and Medicaid. So, Elizabeth, do you think that there's a real chance they would actually defer at this point, say, we're going to decide this first point on this Anti-Injunction Act, but we're not going to get to the case until after the law kicks in?
I think it's very hard to predict, but both the federal government and the folks who are challenging the mandate have said that you can decide the case now on the merits. You can get to the constitutional issues now. And I think that that's going to be very attractive for the court. On the other hand, even though the federal government is trying to say, yes, decide the issue now, if on this technical issue of saying it's a tax, you have to wait till you pay the tax, then it's pretty clear that you've made a very good argument for why the minimum coverage provision is a valid constitutional exercise of Congress's power to tax and spend.
And Tom, I'll give you the last word responding to that particular issue. Is it a legitimate use of congressional power?
Well, at the end of the day, I think what we are confronted with here is one of the most radical, sweeping expansions of federal power in history at the expense of individual liberty. And I think the court has to satisfy itself that it has jurisdiction, but it hasn't given clear guidance on when the Anti-Injunction Act applies and when it doesn't. So they're not bound by their prior precedent. And I think there's going to be an overwhelming temptation for them to take this case as it is and get to the constitutional issue.
We will see in 3 weeks, and we'll have you back for some more discussions ahead of that. A big case coming down the pike. Thank you both for coming in.
Perfect. Thanks, Shannon.
Thank you.